Philippine Reports Annotated Volume 69 page 485. Docket number 46853. This case, Manila Trading and Supply Company vs. Zulueta et al., was promulgated on January 30, 1940. This petition for review on certiorari was decided by the Supreme Court en banc. The decision was penned by Justice Laurel. Here is the opinion of the court.
This is a petition for a writ of certiorari to review the decision of the Court of Industrial Relations, promulgated on August 8, 1929, denying the petitioner's motion for reconsideration of its previous order, directing the reinstatement of laborer Filomeno Ramallo. On July 7, 1938, the Secretary of Labor apprised the Court of Industrial Relations of a labor dispute existing between the petitioner company and its employees, who were members of the Philippine Labor Union, which was forthwith docketed as case number 49 and entitled, Philippine Labor Union vs. Manila Trading and Supply Company. A preliminary hearing was held, after which, on August 6, 1938, the respondent court entered an order requiring the company, inter alia, not to dismiss any of its employees and laborers, except for good cause and with its permission. Subsequently, on June 30, 1939, one of the gatekeepers of the petitioners, Filomeno Ramallo, was suspended for a breach of duty. The breach consisted in, that as gatekeeper of the petitioner, he permitted, contrary to instructions, one of the customers to pass through the exit gate, without paying for the work done on the car. Before this, it is also alleged that he refused to work in the setting up department of the company, when ordered by his superior. The Philippine Labor Union submitted a petition in case number 49, requesting the reinstatement of the suspended laborer, to which an answer was filed by the company. In its order of July 28, 1939, the respondent court found that the laborer was guilty of the breach imputed to him, but, deciding that his suspension from June 30 to July 28, 1939 was a sufficient punishment, ordered his immediate reinstatement. The petitioner moved for reconsideration, but the respondent Court of Industrial Relations, sitting in banc, denied the motion. Hence, this petition for certiorari. The whole controversy is centered around the right of the Court of Industrial Relations to order the readmission of a laborer who, it is admitted, had been found derelict in the performance of his duties towards his employer. We concede that the right of an employer to freely select or discharge his employees is subject to regulation by the state, basically in the exercise of its paramount police power. Commonwealth Acts numbers 103 and 213. But much as we should expand beyond economic orthodoxy, we hold that an employer cannot legally be compelled to continue with the employment of a person who admittedly was guilty of misfeasance or malfeasance towards his employer, and whose continuance in the service of the latter is patently inimical to his interests. The law, in protecting the rights of the laborer, authorizes neither oppression nor self-destruction of the employer. There may, of course, be cases where the suspension or dismissal of an employee is whimsical, or unjustified or otherwise illegal, in which case he will be protected. Each case will be scrutinized carefully, and the proper authorities will go to the core of the controversy, and not close their eyes to the real situation. This is not, however, the case here. The writ of certiorari prayed for is hereby granted, and the order of the Court of Industrial Relations appealed from, reversed, without pronouncement regarding costs. So ordered. Chief Justice of Encina and Justices Villarreal, Imperial, Diaz, and Concepcion concur. Writ granted.